So thank you, Mr Chair. That's my lot.
Honourable Leanne Dalziel.
Mr Chairman, I'm grateful to have another opportunity to contribute to this part of the bill, and the reason why is that I've listened to the discussion, the debate go on beyond my original contribution, which was one where I was totally upfront with the House. I said I wasn't on the select committee that considered this bill. I hadn't read the background material. Of course, I've spent my dinner break going back and printing out all of the documents from the Select Committee, from the departmental report, and all the additional advice that was received on this particular matter, because I think that the issue is actually very important. And I think when Dennis O'Rourke moved his amendment, his supplementary order paper, I don't know that he realised that he would spark off such a significant inquiry in the House. But it is because so few members of that original Select Committee that heard all of the advice and heard all the evidence, that very few of them are actually in this House. And I think Jackie Dean is the only one who's contributed to the entire debate who actually sat on that Select Committee and heard that advice firsthand. So I went away and, as I say, I've printed out the advice, and it's very interesting to follow on from the member who's just resumed his seat, Ian McKelvey, because what Ian McKelvey just told this House was that the Human Rights Commission was kind of for it and against it, wasn't it? I mean, I think it was a little bit for and a little bit against. I can't recall exactly how he described it. Let me quote what the Human Rights Commission actually said. The Commission believes that permanent excusals will discriminate against older people. It also takes issue with the advice of the Attorney-General that this amendment is not a breach of the New Zealand Bill of Rights Act, the Bill of Rights. The Commission considers the amendment to be discriminatory and not justifiable under the Bill of Rights. I wonder whether the members actually got the quote, that he has got the quote with him, and he's looking very embarrassed, I think, right at this moment, when he suggested that it wasn't, when he said that the Human Rights Commission didn't really, give a strong view on this matter. I think that's a pretty strong view. And the reason that the Human Rights Commission gave this view was that they had done a little bit of background homework into why we ended up in this situation in the first place. And I think we have to go back in time when we didn't have a law that allowed for discrimination based on age. And when National was actually in government back in 1993, perhaps my colleagues can assist in that regard, I was actually here at the time, the Human Rights Amendment legislation went through, and that provided for the removal of discrimination as a ground for discrimination on the basis of age. And so what happened was that there was an obligation set upon governments thereafter to bring their laws up to date so that they in fact complied with this requirement not to discriminate on the variety of grounds that were passed in 1993. And I see the chairman's nodding because he, like me, was there at the time. I'm not allowed to mention that, but the point that I'm making is that with the question of age having been put in place, it was up to each subsequent government to go back through the books and to look where there was discrimination based on age. And there was discrimination in the Juries Act. And that discrimination showed that the discrimination was there in the legislation on the basis that at age 65, no longer were you competent to serve on a jury. And so the law was changed. The law was changed to allow for people to continue to serve on juries beyond the age of 65, which of course was the right and proper thing to do. Now, Parliament at the time decided that, well, since we were changing the law, perhaps what we should do is to allow people the ability to opt out on a particular trial simply on the ground of age. They've always had the right to opt out on the ground of age, so let's just allow them to opt out on the ground of age on a particular trial. And so that's what the law allowed. So instead of fixing the real problem in the law, which is this ongoing discriminatory provision, the Parliament decided on this occasion to actually entrench, Mr Chairman. The Parliament actually decided to entrench the provision that said that not only could they opt out of an individual case, they could actually opt out on a permanent basis simply for the sake of being 65 years of age. Now, when I read the the Ministry of Justice's advice to the Law and Order Select Committee, what I discovered is that the real reason that the Select Committee didn't consider the underlying issue is that this was not an issue referred to it. It was never asked to look at the question of whether 65 was an appropriate age to put in place essentially discriminatory basis for claiming the right never to serve on a jury. Even if you've never served on a jury in your entire life, the one age where perhaps people might have the time to commit to a trial and of course the wisdom to apply their experience to a particular set of facts that they're given, these people have a right to absent themselves from trials forever after, simply on the ground of age. And there is no basis for that, and in fact the Select Committee never really considered the real issue, which was the underlying principle of the legislation worthy of continuing in this day and age. And the number of examples that we've had given to us in the House tonight actually refer to those cases where people have a reason other than age not to want to ever serve on a jury again and not to want to have to continue to reapply. And in fact, this legislation, if it were to stand without paragraph 2 in the offending clause, if it were to continue, then most of the people that apply to have permanent exemptions would continue to have permanent exemptions on paragraph 1, which reads, "The registrar may excuse a person summoned to attend as a juror on an occasion from attending in any court on any occasion if satisfied on a written application for the purpose made by or on behalf of the person that, because of the person's disability or state of health, the person would not, if required to attend as a juror in any court on any occasion, be able to perform a juror's duties satisfactorily." Now that is enough in itself to actually deal with the vast majority of those that apply for an exemption. Now, if you look at paragraph 2 says, "The registrar must excuse a person summoned to attend as a juror on any occasion from attending in any court on any occasion if satisfied that the person is of or over the age of 65 years. Well, why do they have to be satisfied? I mean, the truth is that all they've done is taken the language of the first one, which has able to perform a jury's duties satisfactorily, and they've applied the same language. If they're satisfied that they've turned the age of 65, well, what if you're not satisfied with being 65? I don't think I'll ever be satisfied if I'm 65. And I may not get there. If I continue giving addresses like this, I may. But the point that I'm making is that the language of the paragraph 2 is actually framed on paragraph 1, which has a basis for the language to be satisfied. The question whether somebody is 65 years or over is a question of discrimination. It is simply that, and that is what the Human Rights Commission said when it made its submission to the Select Committee, and the Select Committee unfortunately did not take that into account, and unfortunately the previous Speaker for the government didn't actually read the Human Rights Commission's submission to the Select Committee, nor report it accurately from the report to the Select Committee from the Ministry of Justice departmental report. And I think that that's really the issue that we have in front of us tonight. The Select Committee didn't deal with the underlying issue, and I believe this House has an obligation to do so, and that is to support the amendment moved by my colleague, Dennis O'Rourke.
Mr Chair. Honourable Judith Collins.
Mr Chair, I'll just take a short call to deal with some of the issues raised by the Honourable Leanne Dalziel.